Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be California Legislature stripping property rights. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. If you were listening to the show live, the name of the song was Beautiful Life. It was written by Ace of Base. The actual song was released in 1994, written by Jonas Berggren. And this was a Swedish group, and he actually wrote that on an airplane when he was flying back from vacation from Spain. Okay, let's talk about the show format, and that is we'll always have an opening topic. And then we'll open it up for questions and answers for those people that are in the Zoom meeting room. If you do want to talk to me, please electronically raise your hand. You'll see that in the toolbar on the bottom. And if you don't see it, then go into a little folder at the bottom that's called Reactions, and it'll be in there. Also, for those people who are watching on YouTube, I would appreciate it if you could hit that like button and subscribe to the channel. Also, you guys in the watching on YouTube, if you do want to participate in the Zoom meeting room, the way you get the credentials would be to go to my website, evict123.com, and then you will be able to see the credentials to join if you want to go into the Zoom room at Saturdays at 3 o'clock. Also, if you are on YouTube, you can always leave your questions in the comments, and I promise you I will get to them. Okay, so let's talk about the first announcement of the day, and that is August 20th. We're going to have a trade show at the Long Beach Convention Center sponsored by the Apartment Owners Association. And I think we have a special guest here, which I'm going to ask you to unmute yourself. And that is, we have the president of the Apartment Owners Association, and his name is Jeff Fowler. Say hello.
Hey, Dennis, thanks so much for having me on. Yeah, August 20th, it's a free event. So whether you're a member of AOA or not, people get to go. And then I think there's someone we have a pretty dynamic speaker. We have one dynamic speaker that's going to be there. I think he is going to be speaking at 1:15. Is that correct?
That is correct.
What topic are you covering?
We're talking about habitability lawsuits and also discrimination lawsuits, how to prevent them. I have a booth, so I'll be there the whole day right outside the seminar meeting room, which is seminar meeting room A. So if you guys want to come over to my booth, I'll answer your questions personally. I'll even take a selfie with you, and we have a bunch of handouts. But why don't you tell us a little bit more about what's going on with the trade show?
Yeah, absolutely. It's actually a really big show. There's going to be over 150 different vendors that are there. And these are all people that are trying to do business with people who own rental properties. So they're going to have great ideas for you. You're going to see people face to face instead of just something that you might see over the internet. So that's valuable in and of itself. And then there's about 20 different seminars, either 20 or 40-minute seminars that are going to be going on throughout the day. And yeah, so it's just an incredible time to really invest into yourself and into the investments that you're making, working smarter instead of harder. You're probably doing both. You're probably already going smarter and harder. But anyway, it's a great time. We invite you out. We're doing a toy drive. And so like an unwrapped toy. We're gathering those together. Union Rescue Mission will take those and distribute those to needy children. But again, it's free. And if you've never ever been an AOA member before, you get a free all access membership, 6-month membership. We don't even take payment information. So there's literally no strings attached to it. And we would like you to be our guest on that day.
Well, thank you very much. And I'm really looking forward to this. And I'm telling you, everybody listening out there, This is such a smart investment of knowledge that you will get. You will learn how to operate your buildings more economically, and also more efficiently. So coming out there, get the knowledge, talk to these vendors at the booth. I mean, you're talking from accountants to property management to plumbers to contractors, and you'll really see what's there all in one location. And again, it's free.
Right. Oh, yeah. And what you need to do is you need to go to aoausa.com to register. So just do that for sure. aoausa.com, register, and you'll also see the whole breakdown of who's speaking, what they're talking about. So everything from estate planning, again, to having Dennis Block speak there. So you just will not want to miss it, especially when you take a look at who's going to be there.
Anyway, thank you very much, Jeff. We're going to move on, but again, don't forget August 20th. It's all day. In fact, Jeff will be giving a seminar at 7:30 in the morning. So you can actually get there that early and you'll hear Jeff's seminar. And once again, I'll be speaking at 1:15. I did want to move on now to something that I wrote a tweet the other day, and actually I've gotten over 10,000 people have seen this tweet. So I wanted to show you this. And the tweet started out at definition of insanity. To serve a simple 3-day notice to pay rent or quit under Los Angeles rent control, you need to first have 3 notices posted on your property, and you need to serve an additional notice with the 3-day notice. You also need to upload the notice to the city. You also need to have the unit registered, and a copy of the registration has to be already been sent to the tenant. And last, you even have to have previously paid interest to the tenant on the security deposit that you're holding. Is this not clear that the city is attempting to have every landlord lose their eviction case? And the answer is yes. That's exactly what we're talking about here. So it is insane, the regulations that are being foisted upon income property owners in the state of California, which brings us to our opening topic. And what is that opening topic? It is the California Legislature is stripping property rights. That's right. What a surprise. They're stripping property rights. This was Assembly Bill 130, which went into effect on July 1st, 2025. And this significantly limited the fines that homeowners association can impose upon homeowners for violation of their covenants, conditions, and restrictions, the CC&Rs. So what is this bill all about? Well, if you have a homeowner that is violating the CC&Rs, the covenants, conditions, and restrictions, the homeowners association can only fine that person a maximum of $100, one time, $100. And it specifically states that you can't even impose interest on these fines or additional late charges. They do have an exception, and the exception would be that if the violation deals with a health and safety regulation, then in that situation, and you can prove it, then you can charge more than that $100 maximum. And it does require that these homeowners associations be in immediate compliance with this rule. So if somebody's doing something wrong right now, the most you can charge is $100. And therefore, homeowners associations need to review their CC&Rs, their conditions, covenants, and restrictions to make sure that they're in compliance with AB 130. Now, why do I say that this is an assault on property owners? Because that's exactly what it is. So let's take, for example, that you move into a planned community, a gated community, or a condominium association, and before you buy, as a good homeowner, you're going to read those bylaws, those covenants, conditions, and restrictions, and you say to yourself, hey, this is exactly the lifestyle that I want. This is exactly the lifestyle, and I agree with these provisions. And I want to make sure that if I move in here, that everybody is going to agree to these provisions. Well, let's show you something right here. And that is, you have this beautiful home in this gated community, and you have a neighbor who happens to own an 18-wheeler. And he decides, in his ultimate wisdom, that he's going to park that in front of his house. Well, guess what? All the other homeowners are going to be up in arms about this. But based on the morons who run our California legislature, the most the homeowners association can find this owner is a total of $100. And that means that that 18-wheeler can sit there. Or, for example, what if the guy is a boating enthusiast and he has his boat that he wants to park in front of his house? Well, maybe he likes it there, but nobody else wants it there. And what if maybe this same owner wants to paint his house a shocking pink color? Now, what is that going to do to the value of your home? So, of course, this homeowner is gladly going to pay the one-time fee of $100. Gladly is going to pay this fee because that's all you can charge him. Why the California legislature chose to get themselves involved in this bill, AB 130, and prevent homeowners association from carrying out what they want to have, which is a responsible community with responsible rules. Why should they get involved in our property rights? Again, you as a homeowner chose to move into this condominium. You chose to move into this planned housing community. And on that basis, you agree to those rules. And quite frankly, that's what keeps the value up for all the other homeowners, okay? So that it's not going to look something out of the ordinary. If this guy's not cutting his lawn and it looks like garbage, he could normally get fined maybe $100 a day. Good, but not anymore based on the people who run our California legislatures. Well, let's move on now to another one, and that is landlords are now forced to fill a vacant unit at a discount rent. How could that possibly be? That landlords are now forced to fill a vacant unit at discount rent? You mean I can't get market rent? That's insanity. Well, we have to deal with another California legislature rule, which is AB Assembly Bill 1620. So let's take for an example that you have a two-story building, all with one bedrooms. And one of the units on the top floor is paying very low rent. And one of the units on the bottom floor is paying very low rent. So, to your happiness, that tenant on the bottom floor decides to move, okay? So what do you do if that tenant decides to move? Well, obviously it's an old unit. So what you're going to do is you're going to renovate that unit. And look at the beautiful job you did putting this unit back into pristine condition. And this cost you about $20,000 worth of upgrades. You redid the kitchen, you redid the floors, you painted, you made it look perfect. Why did you do that? Because you now know that you could get maximum rent for this unit. Maximum rent for this unit. Well, the tenant on the top floor who's paying low rent comes to you and say, hey, I would like to move to that bottom unit. And you say to yourself, great, come on down. And you know what the rent is going to be now? It's going to be $3,500 for this unit. I know you were only paying $800, but now if you want to move down, I am thrilled to rent it to you. You've always been a good tenant. But you see, this tenant who's in the upstairs unit says to you, no, I want to move downstairs and I want to pay the same rent that I was paying upstairs. And you say, no, you can't. I just went through $20,000 worth of upgrades and renovation so that I get maximum rent. if you want to pay me the $3,500, this is a vacant unit. I should be able to do whatever I want. Well, the answer is you can't. You're going to need to rent it to this special tenant for the same price, $800 was he was paying upstairs. And why is that? Well, let me read this code section to you. California Code Section AB 1620 states, under this statute, a tenant with permanent mobility disabilities may move to a comparable unit or smaller unit in the same building without losing their rent level. So therefore, if this person has a permanent disability based on mobility, and therefore it's difficult for him to get to the second floor, you are duty bound under this statute to rent him that unit that you've now spent $20,000 fixing up, and yet you can't get any more rent because that would be a violation. So what happens to the $20,000 in renovation that you spent? And the answer is that's thrown out the window because the California legislature is now dictated to you what you can charge for a vacant unit where you spent lots of money renovating it and making it look good. Clearly, this is another theft of property rights by our state government. And that concludes my topic of the day, where the California legislature is stripping owners of their property rights. We're now going to open it up to questions and answers for those people that are in the Zoom meeting room. Again, if you do want to talk to me, please electronically raise your hand. If you don't see that symbol, then please look in that folder called reactions, and then you'll see it in there. Remember that this broadcast is for informational purposes only. It is not a substitute for legal advice. If you do have a question for me, make sure that it's a general question. If you do have a specific case with my office, please save that for the office. We only answer general questions here. When I do call on you, be so kind as to have your camera on, because it makes it much more enjoyable for the audience and for myself. And if you guys are watching again on YouTube, please hit that like button and subscribe to the channel because it does help me. And also, if you do have a question, y'all still answer it. Just put it into the comments and I promise you I'll get to it. We're now going to open it up to our first caller of the day, and that is Juan. How are you, sir?
Yeah, I'm doing good. How you doing?
I'm doing good, Juan.
I have just a small two-part question. You remember you talked about, I live in the city of Whittier. It's not rent control or anything like that. And you said that we still have to post these. I got them from your website, or no?
No, I said you didn't have to post it. Those
Okay.
notices are only for the city of Los Angeles, not the city of
Okay,
Whittier.
that's fine. Take that out of the way. Now, there's one more thing I renewed the contract with my tenant August 1st, and I have a stipulation in there saying that I can go in doing the inspection and changing the air filters every 3 to 4 months. Well, we did that, but they love their privacy, and we did everything. They said, in order for us to sign this, that you guys went in, we want you to change it to 6 months. You can change the air filters or the inspection every 6 months, but it's already in writing. And
Did they already sign that contract?
oh, they already signed it. They signed it like 3 months ago.
Well, between me and you, I think 6 months is more than enough to do an inspection. So I probably
Okay.
wouldn't fight them. Legally speaking, if they signed it, then you're allowed to go in every 3 months. Otherwise, it would be a violation of the contract. But we deal with human lives here, and I think 6 months to go in there. You don't need to change filters every 3 months, that's for sure. And you don't need to check smoke detectors. 6 months is more than enough. So I think you should secede to what they're asking for.
All right. Because I did write to them. I said, you know what? I'm going to seek more advice, but right now it stays the same. But I will email them, talk to them, and we can do every 6 months. That's fine. Thank you.
Thank you, Juan. We're moving on to Tara Lewis. I'm going to ask you to unmute yourself.
Hi,
Terry?
Dennis.
Hi there.
Yeah, I have an RSO building, and one of the tenants, he's been there for 2 years, and he travels to Europe a lot. So what he did the last couple of days is he went ahead and subleased his unit out. And evidently he used some kind of clone, one of those Airbnb clones. And I don't know what the contract is about. I'm going to go out and knock on the door and try and speak to these 30-day tenants that are up there. But evidently he called the police because they brought additional people in, and then they were making a bunch of noise. So the tenant called from Europe saying, "Hey, listen, I wasn't supposed to do this, but I went ahead and subleased the unit out to a clone Airbnb for 30 days, and I won't be back until for at least 6 weeks. But I'm just letting you know that the police were there to speak to one of the tenants or two tenants that weren't supposed to be part of the contract." I told him that he was in breach of his rental agreement with me, which is an AOA agreement. I wanted to know what my best course of action at this point is.
Well, if the tenants have been there, these subtenants have been there more than 30 days, on the 31st day, then you can serve your tenant with a 3-day notice to perform or quit, giving them 3 days to get rid of these subtenants. If the subtenants are there after the 3rd day, then you have the right to evict. Now, when I say serve your tenant, even though your tenant's in Europe, you can serve it by merely just posting it on the door and mailing it, since your tenant is not there. But if these people are there longer than 30 days, they become occupants, and that would be a violation of your contract.
But at this point, I'm not going to really do anything. Just confirm that, because evidently they have some contract, because evidently when the police came out, I got this information from one of the other tenants, that they showed the police officer a document saying that they had this 30-day contract. So I'm going to get a copy of that contract. I'm going to go to the
Yeah, get a copy of the contract. But again, by the time under the city laws, that tenant occupant has to be there 30 days before they become, quote, a resident. So if these people stay beyond the 30-day period, on the 31st day, again, serve your tenant with a notice to perform or quit to get rid of these people. And if these people are there after 3 days, you have the right to bring forth an eviction to get everyone off the property. Anyway,
Okay,
thank you very much. We are going to move on to, it says here, LKJLC. I'm going to ask you to unmute yourself. LKJLC, are you there? Oh, there you go.
Hi, Dennis. I have a question about the 3-day notice and how that incorporates into the unlawful detainer complaint. So let's say the rent is $1,000 a month and due on the 1st of the month. And if the tenant doesn't pay, and let's say I serve a 3-day notice, and let's say I serve it on the 10th or 11th of the month, and it expires, let's say exactly midway in the month, the 15th of the month. Does that mean that from the second half of the month, I'm not entitled to collect rent? It's only damages?
Okay. It's kind of a technical question that you're asking. When you serve the 3-day notice, you're serving it for the entire month. So we'll call that August. You're serving it for all. So the tenant has 3 days to pay. If he doesn't, you're going to file your eviction lawsuit, and the amount that you're asking for is the $1,000 rent. Now, obviously, once that 3-day notice expires, you're not allowed to accept any further rent ever. And then from the lawsuit point of view, you're entitled to the daily rental value for every day they stay there from September forward in time. So if the rent's $1,000, that would be $33.33 per day. So the demand of the complaint would be asking for all the rent for August, $1,000 plus $33.33 per day from September 1 forward in time.
So here's the confusion, and because this happened to me, when I filled out the UD complaint, paragraph 19, which is the relief section that you're asking for, it's asking for past due rent. Does that number have to match the number that's in the 3-day notice?
And the answer to that question is yes. That's going to be $1,000 there. Then when you say the daily damage rate, it's going to be $33.33.
So 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 then doesn't that contradict the fact that once the 3-day notice expires, if it expires in the middle of August, so can I still collect rent?
Obviously, what you don't understand is rent is not apportionable. It's due the day it's due. So on the 1st of August, they owe $1,000. Even if they moved out without giving you notice, they still owe the $1,000 because rent is not apportionable. It's all due on the due date. Anyway, thank you very much. That was kind of a technical one there. We're going to go to an old friend who I haven't seen for a while. Jim Polina, how the hell are you? Unmute yourself, sir.
Are we okay?
Yes.
Good. All right. Good to see you again. It's been a while. Couple questions. One is, if I am the winning bidder at a trustee auction as an owner occupant for a property that is either in the city of LA or the county of LA, whether it's RSO or the other, am I going to have difficulty evicting a tenant?
The answer is you do need to have cause to evict a tenant in both of those areas. But however, if you're going to be moving in, then you'll just merely have to go through the procedures that either of those municipalities or the county requires, and then you'll be able to ask that tenant to move. You are going to need to pay relocation.
And I can do that without cause.
You can do that without cause, correct?
Okay.
Well,
Second question.
no, the cause is that you're moving in. If you're
Oh.
not moving in, then they're protected tenants.
Oh, I see. Okay, I get it. Second question. Did I hear you say a while back that the state of California is now offering legal assistance to all tenants throughout the state on unlawful detainers?
There was a bill passed that they were offering it, not necessarily in all jurisdictions, but I know, for example, that the city of Los Angeles and the unincorporated areas of LA County are now offering free legal services. And in fact, in both of those locales, you have to attach the, hey, you're entitled to a free attorney to any termination notice that you serve on your tenant. Incredible.
Thank you, Dennis.
Thank you, sir. We are moving on to Harold Rhodes. What do you got different today, young sir?
Okay, real quick. I feel like lately it's like the Dennis apocalypse beatdown show. We just keep getting these atomic blasts of the state, the city, the county, all anti-landlord. It's just a beatdown, man. We got to form something to go against these people. Anyways, back to the theme. If I ever move back to my place, is there any wrench the tenant can put in the fan if I give him the 60-day notice to leave? There's nothing he can do to foil.
Not in your situation, because this is a border inside your own house. So you're fine. You can just do that 60-day notice.
I just get mega paranoid sometimes listening to you.
I hear you. Now I got a question for you, Harold. Are you ready?
Yeah.
Are you coming down on August 20th to the Unbelievable Apartment Owners Association trade show in Long Beach?
Since you asked me, I will. But here's the other thing. I don't know if you realize how famous you are, but every time you do these things, it's standing room only. So anybody who goes there, you better go early to get a seat. It's definitely standing room only to see Dennis.
And actually, I'll tell you a secret, Harold. If you sit in the front row for my speech at 1:15, I'll pick on you. How's that?
Love it. I'll be there, or be square. Both.
Thank you very much. Always love Harold. Let's see. Let's talk to Brett's iPhone. How are you?
I'm great, Dennis. How are you? I got two quick questions for you. On a LA RSO property where title was held by an LLC, I had to quit claim 50% of it to do a just cause eviction. So now that the process is finished, is there a waiting time? Because I'm feeling a bit naked right now.
Okay, so what you're saying for the audience is that you're doing what they call an owner or a family member move-in, but if your property is held as an LLC, then you can't do it because an LLC doesn't have any family. It's just a piece of paper. So you had the LLC had the deed to your individual name 50%. So now I'm supposing that you got the tenant to vacate, you're now legitimately living there or your family member is living there. Can you now immediately put it back? Is there any time period? And the answer is you can do it immediately. Once you're in, you're in. But again, you're going to have to comply with the rules, which states that the family member or yourself has to be there for the city of Los Angeles for at least 2 years.
Correct. But one more question. So in the eviction process, the tenant left in a, not kindly. So they reported me to the health department. They claimed harassment. Everything they could do, they did, which triggered a what do you call it? The systematic code enforcement. So that's imminently about to happen. And my question is, do I have to let the inspectors into the units that I'm controlling that don't have tenants and where no rent is being collected?
I don't believe so. That's exempt. So I would object to that. There was a federal case that said that even that tenants can object for these people coming in as an unwarranted intrusion unless there's some probable cause, which of course they wouldn't have. So on that basis, I think you can reject that. The problem with these is that these building inspectors are very vindictive. And if you don't let them into one unit, then they're going to find 100 things wrong with every other unit. So be on your guard.
Okay, appreciate it.
Good question. Thank you very much, sir. We do have room for lots more people. If you want to electronically raise your hand, don't be shy. We're going to now talk to Zena McFarland. How are you?
I'm fine. How are you, Dennis?
I'm good, thank you.
All right, I got a couple of scenarios I want to run by you. I'm going to be teaching landlord tenant law at a couple of community colleges, and I like to have just scenarios for the students to work out. So actually had one, but you bring up the permanent person with mobility issues.
Yes, that's this law that
Right.
states that if you have a permanent mobility disability and you want to move to a like unit or a smaller unit in the building that's vacant, then you have the right to demand that the landlord put you in at the same rate that what he was paying for the other unit.
Okay, so my question to that is, if I'm aware that I have tenants that would probably need to be moved to a lower floor, couldn't I offer them that unit in writing before I did all of that remodeling and renovation?
Absolutely. You could certainly do it that way, but in this case, it kind of was a surprise. The scenario that I picked was a surprise, and
Okay,
that's why they did that. So, yeah, of course you could do that. You don't have to
okay,
renovate the unit. It's a comparable unit.
correct. And then my question would be if they said no, and then later I renovate the unit and they came back and changed their mind, am I obligated to rent to them at that lower rate?
I just get a gun and shoot him at that point. But I
Okay,
would.
one more scenario. Um, or if a tenant signs the rental agreement that states that they will receive their deposits in payments and the deposit is broken down, is that legal?
What you're saying is that upon move-in, they don't have all the security deposit money, so they're going to be making it in payments. Is that correct?
That's correct, but they will also receive it on the back end. After they move, they agree and sign on the contract that they are willing to receive their deposit in payments.
That part would be against public policy and is in violation of the law. So you can take payments on the way in, but there's no basis of you paying the tenant payments on the way out. By the way, if a tenant ever states, "Hey, I don't have all the security deposit, but I'm willing to pay it in payments," do not rent to that person. For sure, you will be evicting that person. For sure, they'll never make the payments on their security deposit. Now, I got a question for you, Zena. You say
Yes.
you're going to be teaching landlord tenant law. What is your background?
Um, well, I've been a real estate agent for over, I'll just say since 2000, 2000 and something. I don't know, 2003. And so I've been in the industry from that perspective. I did a little bit on the selling homes and doing a lot of loans, but I think I've got my most experience through being a property manager or helping out family members. So, and renting on my own property. So I kind of know a lot, and I'm always taking the refresher courses for landlord and tenant law. So,
Excellent. Well, do good out there and keep up the battle. Anyway, thank you very much. We are moving on to Julia Jordan. How are you? Julia.
Hi, Dennis.
Hey there.
How are you?
I am good, thank you.
Okay, so I have one question today. So this is a fourplex that's in Inglewood. And basically, this particular tenant does not want to transact the rent in any kind of electronic payment. Therefore, he sent me a note saying, your rent will be there on the 2nd every month in my mailbox, and you can pick it up from there.
In whose mailbox?
His mailbox.
Okay. Well, you have, first of all, under California law, you can't have the only method of payment as electronic. Okay. You have to give them another option. However, that would be something that you give him an address where he can mail it to you. In fact, I don't even think you're legally allowed to go into, quote, his mailbox. So you tell him that's unacceptable. If you don't want to pay it electronically, I can give you actually, you can go to my bank and I'll give you my account number and I'll give you the name of the bank and you can deposit it directly. Or I'm going to give you a physical address or a P.O. box where you can mail it to. But under any circumstances, I'm not taking it out of your mailbox.
Okay, that's what I wanted to know. Thank you.
Good question. Okay, we're moving on to Bruce has an iPhone. Say hello, sir. Bruce's iPhone, are you there? Okay, Bruce, we're going to move on. Sleep at the wheel. Moving on to Albert, I'm going to ask you to unmute yourself.
Hi, Dennis. I just wanted to clarify about AB 1620. This does not apply to a tenant that, let's say, has some knee problem and he says that I want to move. I mean, where is the limit?
The language in the statute says permanent mobility disabilities, whatever that means, but that's what the language of the statute says.
I am.
So if he gets a doctor to say that and you get a vacant unit that's similar size, then you're going to have, so let's pretend that he's been there for 20 years. There was another unit where you did renovate that unit and the tenant just moved out, but obviously you're getting much more for that unit. And you were because the tenant just moved out. If he wants to move into that unit, you're again stuck.
Even though they are both on the, let's say, same level, same first floor?
No, it would have to be a different floor would be because it wouldn't make any sense unless he's going to say, well, that unit is right next to the parking lot and therefore I don't have to travel as far. But if they can make an argument, you're stuck.
One other quick question. I have a tenant who has been there. The original tenant left 2 years ago and this guy was living with this tenant and he pays rent and is staying there. And the original tenant is just gone, disappeared for like at least a year and a half. Do I have any?
Well, you've been taking rent from this stranger?
Yes.
Did the stranger move in after the original tenant or they both moved in together?
I think they were both together.
Okay, so then the other tenant is just as good a tenant as the stranger. They're both proper tenants. And the fact that one tenant left, it doesn't change anything. The rent is whatever the rent is, and he's obviously been paying you rent for this period of time, correct?
But he's not on the lease. Is that a cause? I mean, he's not on the lease?
It's unusual when you rent out a unit, every adult who's moving in needs to be included in the rental agreement and sign the rental agreement. However, under, let's say, LA rent control, if that's what this property is located in, then that person has the same rights, even if you didn't put them into the contract. Therefore, it's imperative when you rent out a unit, every adult will be named in the rental agreement. Every adult will be signing that rental agreement.
Thank you so much, Dennis. I appreciate it.
Okay, thank you. Moving on to Bruce, I'm going to give you another chance, but I'm going to go first to Ovazine Shannon. I'm going to ask you to unmute yourself. Ovazine, Unmute.
Can
Okay,
you hear me?
now I can.
Hi, Dennis. How are you?
I am good, thank you.
You know you are my attorney, and I have a unique name, so you should know. Um,
Overseas.
yes.
You
I
have the
have two.
property out in San Bernardino?
No,
Okay,
no. I'm surprised at you, but okay. I have two quick questions.
sure.
With the new air conditioning law they just passed, I just started having mini splits installed in my units one by one. Do you know if mini splits are acceptable because they go by the size of the unit?
Well, first of all, this is only for properties located in unincorporated areas of LA County. It has been approved, but it's not law yet. And it does state that you have to install either an air conditioner, some sort of a cooling unit, or some sort of building material so that the unit will never get above 82 degrees. So first of all, is your property located in an unincorporated area of LA County?
Unincorporated, yes.
Okay, so in most situations, depending on where the building is, the temperature might not rise above 82 even in the worst of days. But technically, if it does, then you have to install something, a small air conditioner, large air conditioner, or putting something on the windows to dissipate the heat so that it will never get above 82. That's what the law states.
Okay, because I want to install some more units like that. You know, a mini split is like what the hotels use. We can go heat or air. That's what I've
Yes.
been installing.
Yeah, as long as it will cool the apartment down, that's it. And 82 is pretty hot. So if you have any kind of an air conditioner, I think that would keep it at least to 82 or less.
Okay, and regarding 1620, if we were to move a tenant to the other unit, we can rent the one they moved from. We can increase that one, correct?
Absolutely, you can.
Okay. All right, thank you.
And thank you. Moving along to Bruce's iPhone. Are you ready to unmute yourself, sir? Mr. Bruce, I think you're asleep at the wheel. Okay, we're moving on to JP iPhone. Ask you to unmute yourself.
Hello, Dennis. Can you hear me?
Perfectly.
Hi, Dennis. Okay. I have informed that the not so wonderful LA Board of Supervisors have extended another 30 days for anti-price gouging. Maximum is 10% in terms of raising whatever previous rate.
Okay, first of all, that wouldn't be the county. That's on a state level, and it is our wonderful governor who has extended the state of emergency to the end of October, which means that if you had the right to raise the rent above 10%, I wouldn't do it. You can raise it 10%, assuming you have the legal ability to do so. For example, a single-family home, townhouse, or a condominium, regardless of where it's located. I would just raise it 10% now to take effect as of October 1, but come November 1, you'll be able to raise it to market level.
So, okay, I'm a little confused then. So what is this? So why did the LA Board of Supervisors keep on another 30-day extension regarding with CA Penal Code 396 subdivision E?
Again, they
Yeah.
don't have any, you're looking at that incorrectly. The only one who can declare a state of emergency is the governor. Now, the county was dealing with this other garbage, which states that if anybody claimed that they were a victim of the fire, and assuming they served a 7-day on the 7th of each month, hey, this month I can't pay because I'm still a victim of the fire. They've been extending that one. I'm not sure what they extended it to, but that's still in existence, maybe to the end of October, where if you walk up to your landlord by the 7th of the month and hand them a note saying, hey, I'm impacted by the fire, he doesn't have to pay that month's rent. Total theft of property rights.
So how does this affect, I don't know if anybody else in a situation with a recent vacant unit, apartment unit in the city of Los Angeles, non-RSO. So how does that affect with their, does the ruling affect with that situation or just go with?
I believe that under the Costa-Hawkins law, the Rental Housing Act, that you can raise the rent to whatever you like, assuming you have the legal, assuming it's not a rent controlled area. So,
It's
but
not.
I've been advising my clients that if a unit becomes vacant, rent it for whatever the hell you want to rent it for. However, if
Okay.
there's an existing tenant there and you're just raising rent, I would take a more cautious view. Just raise it 10% now, and then come November 1st, then you can raise it to unlimited amount.
Okay. Because right now in our situation, we are currently like doing all the the repairs and things like that to get it ready. And just want to make sure that, yeah, we don't get a nice little letter from the state of California Attorney General Rob Bonta saying, yeah, you are in violation, you get complaints, blah, blah, blah,
And,
that sort of thing.
that I doubt it would come up since it's a vacant unit. But if it did, then I would just quote Costa Hawkins and say, how do you get around that? Because Costa Hawkins says that notwithstanding any other law, you
law.
can. So I don't see how they get around that.
So to be in the safe side, you mentioned about the end of October.
Yes, because that's when the state of emergency is going to be over.
Okay, so maybe in my situation, maybe just wait till the end of October, and
Yeah, if you want to
then
be on the safe side, yes. But who
okay,
knows?
so
Our moronic governor could extend the state of emergency again. Look what they
I
did with
hope.
COVID. They kept it going for 4 years. So,
Wow. Okay, right. Thank you very much, Dennis.
and thank you. Always nice talking with you. Moving on to Alec. How are you?
Hi, Dennis. I'm good. How are you? Thank you so
I'm
much
good.
for all your support. Quick question. I'm in process of purchasing a multifamily in city of Burbank, and from rent roll, the agent reported that it was basically showed that one of the tenant is Section 8 and paying rent on time. But during the inspection, I found out that from other neighbors that lady who is under the Section 8, she's gone for at least 4 or 5 years, and her grandson and his girlfriend has been living there. And the list that I reviewed, it's only the lady name who
Right. And of
was
course,
on
this is a
Section 8.
fraud
Yeah.
on Section 8. You should advise once you become the owner, you should advise your Section 8 advisor that the tenant doesn't live there. You can start an immediate eviction on the basis that they're in violation of their rental agreement by having a stranger there. It's actually a double whammy because they're literally committing a fraud on Section 8.
Mhm. And if they are not reporting, is landlord also committing a fraud that not reporting or not letting the Section 8 know?
They probably have an obligation, but he's going to say he didn't know. So,
Mhm. Okay. All right. Thank you so much. I appreciate it.
thank you. Moving on to Roman. How are you?
I'm good, Dennis. How are you?
Fine.
I have a question. I have a tenant who moved into the apartment. It's one bedroom apartment. They moved in 2002, 23 years ago. And they had they came from another state. They had 3 small children, and I rented them this apartment. 23 years later, these small children are adults, and they still live in this one bedroom apartment. And is it anything I can do?
This is
They pay
under the
minimal
rent.
rent, and anything I can do to increase
I'm
the
sorry,
rent?
what city is this?
City of Los Angeles.
No, there's nothing you can do. These are all protected tenants. They all moved in together. And the fact that tenants grew up and became adults, that's just the way it works in life. So there's nothing that you can do in that case, Roman.
But they're still in one bedroom apartment, 5 adults.
There is no limit in terms of overcrowding for a unit. Those laws aren't followed or don't exist. And again, this is the way it was rented. These 5 people have lived there for forever, whether they were small or large. So it makes no difference.
Okay, thanks, Dennis.
Thank you. Moving on to, let's move on to Zena McFarland. I see you have another question. Go ahead.
Yes. It's about what is it? The pets, emotional support animals. Are you what's is there a limit as to what is considered an emotional support animal? For
Well, the
example,
law,
a turtle, a fish?
well, no, it's whatever. The law states that if a medical professional has treated with your tenant and describes that your tenant has a disability and needs the services of a comfort animal,
Okay.
and this person, this doctor or medical professional has to put his license number down on this letter, and has to be located in the state of California. If he issues this letter, whether it's a goldfish or a cat, as long as it's a legal animal. For example, if he says that you're entitled to have your emotional support animal is a chicken, well, chickens are not allowed to be in a residential apartment. So you could object on that basis. But if it's any kind of a normal pet that is allowed, then if they have that letter, you're stuck.
So what about the number? Can it have 2 emotional support animals?
Oh, they can have 2, 3. I mean, you can't exceed, I think in the city of Los Angeles, the maximum is 4 dogs and 4 cats for a unit. So if they had 5, for example, I mean, we see these professionals, these medical professionals write anything, they say, oh yes, he needs, 3 cats, and 2 dogs. I mean, it's insane. You can get them to write whatever you want.
Okay, thank you.
All right, thank you. Well, ladies and gentlemen, we've come to the end of another wonderful edition of Zoom Landlord Tenant Talk Radio. Once again, every Saturday at 3 p.m. You guys are watching on YouTube. Please hit that like button and subscribe to my channel. And once again, do not forget, August 20th, Long Beach Convention Center. All you got to do is pay for the parking, and you can come and meet me. Happy to take a selfie with you. I got brochures. And again, stick around for 1:15 because I've got a killer seminar that I'm going to be doing. And with that, ladies and gentlemen, have a great weekend.